Thank you very much. I will speak in English. Thank you very much, Mr. Puppinck, for organizing this very important side event, and also for having introduced this motion for resolution that will be discussed this week. Yes, it is very important for the Council of Europe. It is part, I guess, of the task of the Council of Europe to work on challenges to human rights of any kind, including challenges of human rights when they come on fundamental issues such as equality and also the nature of the norms. It is quite surprising to speak about application of Sharia law in Europe. Many people could imagine that it does not exist. What I would like to say is that, in first hand, that yes, it does exist, and it is important to consider its application. To some extent, it is not surprising that it does exist as long as there is a large Muslim community in Europe and in some countries. It's important for the Council of Europe to assess how those religious norms can be or not compatible with human rights, because we consider human rights as being a universal system. When we speak of human rights, when we consider human rights in Europe, we are not thinking about a European or Occidental set of values, but we are considering human rights as universal values that should apply to some extent everywhere, regardless of religions. I would like also to say that myself as the director of the European Center for Law and Justice, we are also very much concerned by respect of freedom of religion and belief. And we've been working in defense of freedom of religion and belief for many years. And when we discuss Sharia law, of course, we shall also respect freedom of religion of everyone. So it's important. What I would like to say is that, yes, the European Court of Human Rights in the past has already taken a number of positions and decisions on Sharia law, and has ruled a very important ruling in 2003, saying that Sharia is incompatible with the fundamental principles of democracy as set forth in the Convention of Human Rights, in particular regarding the legal status of women. As well, the report that has been adopted and that supports the resolution also says and recognizes that there are structural incompatibilities between Sharia law and the European Convention of Human Rights. When we speak about the European Convention, we shall not think about it only in terms of a positivist legal system, but more as a set of values that pretend to be universal. So when we consider the relationship between Sharia law and the ECLJ, we shall consider the relationship between two systems of norms and of values, and not only between norms. There are a number of incompatibilities between both systems. First, there are some incompatibilities at the level of the norms themselves. So obviously, it is well known that a number of norms are confronting and obviously incompatible. Human rights protect and is based on the equality of every human person, regardless of his sex and religion. It is clearly not the same with Sharia law. Human rights protect freedom of expression and religion and conscience for everyone. It is obviously not the same. Human rights as well protect the freedom to marry after marital age. This is not the same. So, if we look only to the norms, we can observe a number of incompatibilities. But I think this is not sufficient. I think it is important to consider the system as well, the values, the nature of the norms. Human rights has a specific nature. They are, we could say, kinds of natural law. Human rights are natural law. They are based on the human nature. They protect the human nature. And it is because they are based on human nature that they can be universal, regardless of the race, the color, or the religion, or the sex. Whereas at the opposite, Sharia law is religious law. So we have a fundamental and systematic difference of nature between Sharia law, religious law, and human rights as natural law. There is also a difference considering their origin. Human rights are deduced from natural law and from human nature. If they are deduced, it is because it means that you use reason. You analyze human nature, and through your reason, you deduce what is just and good for each situation. You deduce the natural rights and therefore human rights. Whereas religious law, Sharia law, is revealed. It is not deduced through human reason, but it is revealed. And therefore, you don't use the same way your reason to find in each situation what is the proper law. The consequence of this difference is fundamental. I think it is one of the greatest riches of our legal tradition in Western countries, I would say Latin and Greek tradition countries, to have justice and law based on reason and not only based on a kind of positivist or revealed understanding of the norms. It is essential for the protection of freedoms to keep an understanding of the norms as deduced through deliberation and reason. It is because we use reason that we need democracy and deliberation. If you have norms based on revelation, you don't really need any kind of deliberation. So we can remember that there are incompatibilities at two levels. One, at the substantial level, most of the norms, many norms, are directly incompatible. But there is also a problem at the level of the nature of the norms and on the way they are known and understood. So those two levels are important to consider, especially when some legal system would like to accept some norms of the Sharia law, considering that they are not all incompatible. It is true, of course, that some norms of the Sharia law are not incompatible with human rights. They don't conflict. But by nature, they are of a different nature, and they are, I consider, by nature, incompatible with the legal system of natural law and human rights. As a conclusion, I would say that it's very important today for the Council of Europe to consider this problem. We are celebrating the 17th anniversary of the Council of Europe. The purpose of the Council of Europe is to defend freedom and rights of the human citizen in front of any kind of structural danger. The purpose is to set and defend rights and values that are universal, that protect the freedom of the person. The dangers from which we should protect the people change within the time. We had in the past the dangers of the Soviet systems. We can have some other danger of liberal or extremist system. And I think we should also consider the dangers of religious system if they do not accept the application of human rights and the fact that human rights prevail on religious law. So I thank you for your attention.